I'm calling to order a code enforcement hearing of the City of Cape Canaveral. Today's date is December 1st, 2025. My name is Rick Geller. I'm Special Magistrate appointed by the City Council to hear code enforcement cases pursuant to Florida Statutes Chapter 162 and Article 6 of the City Code. This is a quasi-judicial evidentiary proceeding. The burden of proof is on the City to show by a preponderance of the evidence that a code violation exists. In other words, I will determine, based on the evidence presented to me this afternoon, whether it's more likely than not that a violation has occurred. Any alleged violator will have an opportunity to submit rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public who has relevant personal knowledge to testify, even if not called by one of the parties. Anyone who would like to testify, we do have a sign-in sheet at the front of chambers there. Would ask you to please sign that and indicate who you're providing testimony for. Upon request, an alleged violator may ask relevant and material questions of any city witness, and vice versa. The city may ask relevant and material questions of any witnesses for the responding party. I may exclude evidence that I deem irrelevant, immaterial, or unduly repetitious. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken to correct the violation, and any history of previous violations. Under the City Code and the Florida statutes, I may assess and order the payment of a fine of up to $250 per day per violation, and if it's a repeat violation, up to $500 per day, or if the violation is irreparable or irreversible, $5,000. I may also award the cost of any repairs or remedial actions taken by the city. At the conclusion of the hearing, I will issue findings of fact and conclusions of law based on the evidence of record and in order, again, both here from the bench, and I'll memorialize that in writing, and I endeavor to do that within a week, certainly this week, since we're at the beginning of the week. The city will record a certified copy of any order imposing a fine, which will become a lien against the land where a violation occurs, as well as upon any other real or personal property of the violator. Any order that I issue may be appealed by any aggrieved party to the Circuit Court for Brevard County within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings. An appeal is limited to the record presented before me, and administratively, I will mark the city's agenda packet as the city's Exhibit 1. The PowerPoint slides, if there are any, will be Exhibit 2. And at this point, I'm going to ask anyone who intends to offer testimony and evidence to please be sworn in. You swear that the evidence you shall provide shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you very much. This is case number 25-206. Mr. Garganese, are you ready to proceed?
Yes, thank you, Your Honor. Is this microphone iPad?
Yes.
Okay.
I hear you fine.
So my name is Anthony Garganese. I'm the city attorney for Cape Canaveral. I'm here to present on behalf of the city. With me is Gerald Coates, the senior code enforcement officer, and Connor Ford, the senior planner for the city. To the extent that testimony is needed, they may testify. Generally, this case is probably decided on the papers. You have been provided a copy of the exhibits to the notice of violation. All that information has gone to the respondent, and we have some additional documents that I want to submit during the presentation, which I will do at that time. Generally, this is a case involving the unlawful subdivision of land. This is a case that we're going to present about 15 PowerPoint slides, which I think will kind of tell the story of a deliberate indifference to the city's subdivision regulations, notwithstanding several notices that the respondents have received regarding the illegal subdivision of land at issue in this case. They still proceeded intentionally with marketing the property as 4 townhouse units. So let me go through our presentation. The properties in question, their addresses are 117 Jefferson Avenue and 119-121 Jefferson Avenue. The subject property consists of two platted lots, lots 1 and 2, Poinsettia Place, and that's based on a recorded plat from 2022.
Yeah, let me just ask you, because I'm not real familiar with how parcel identifications are done.
Yes, sir.
But there are asterisks, asterisk 1, asterisks before the 1.01. Everything before the blue, there's an asterisk. Are you able to tell me what that means?
Yes. The respondents have proceeded to go to the Brevard County Property Appraiser's office and get 4 tax parcel IDs for the 2 platted lots.
Okay.
And the numbers that were issued by the Brevard County Property Appraiser consist of the asterisk 1 and the asterisk 1.01. Those 2 parcel IDs are related to platted lot 1. And similarly, with respect to asterisk 2 and asterisk 2.01, those 2 tax parcels are related to lot 2. And those are just parcel IDs for tax purposes that the Brevard County Property Appraisers issued.
Okay.
At the respondent's request, not
Okay.
the city's request.
That makes sense to me, and I'm going to be real nitpicky here. Like, some of them have the like asterisk 1, and the others are asterisk dash 1.01. Is that a typo, or does it matter where the asterisk goes? And if you don't know off the top of your head, that's fine. We can look that up.
Yeah, let me get back to that.
I just want to make sure that
It might be a typo.
Right. I just want to make sure in any order that I enter that I correctly identify the parcels.
I'll try to clarify that on rebuttal.
All right. Appreciate it.
Okay, so the property is zoned R2 medium density residential, and the owners are Babber Enterprises LLC, Whittekine Enterprises Inc. There's a little quirkiness to this case, Your Honor, that we spelled out. There was a conveyance by Viger Enterprises LLC by deed to this Whittekine Enterprises LLC, and Whittekine Enterprises LLC, based on our research, is an entity that we believe is non-existent. So Viger Enterprises would be the apparent last valid record owner of title with respect to one of the conveyances. So we noticed both Whittekine Enterprises LLC and Viger Enterprises LLC.
Okay. So is Viger then a respondent as well at this point?
Yes.
Okay.
Just in an abundance of caution.
Right.
They may not even be aware that there's a cloud on title, but we wanted, in an abundance of caution, to list them as respondents
Okay. And
serve them.
All right. And they've been served as well with everyone else.
Yes.
Okay. I'll let you proceed.
Okay. So with respect to the notification summary, we posted the city, Mr. Coates posted the property on November 14th. He posted each of the 4 units that exist on the 2 lots. Then we sent also that same day certified mail. We have confirmed return receipts from Babber Enterprises, both the manager and the registered agent. We also have the registered agent from Viger confirmed. Notices were left for Viger Enterprises, the manager, on 11/20. With respect to Whittekine Enterprises, Inc. and LLC, the non-existent corporation, apparently that notice was attempted to be delivered on 11/17. They in Harmony, Florida, and the notice was forwarded to Denver, Colorado, and notice left on 11/25.
So
we
did get we being the city did get Viger under, they received proper notice through the registered agent. The manager may apparently, if there is a manager, it was forwarded then to some entity I'm assuming this is going to Whittekine, I guess, which is the recipient that the property was transferred to. Is that correct?
Yes.
Okay.
And Whittekine Enterprises, Inc. They're listed as the owner of record on one of the lots. and the LLC is listed on one of the others.
So when we say was forwarded, it was V'ger who forwarded it?
No, it was forwarded by the United States Post Office.
Thank you. By USPS.
And if I may approach,
Yes.
I will submit for the record a summary of the notices, as well as copy of the United States Postal Service's records regarding.
All right. Why don't we, we'll call this City's Exhibit 3.
And I apologize for the voice. I'm getting over a little bit of a cold.
No problem. Okay.
And, whoops. So as I mentioned early on, the nature of this case is an unauthorized subdivision of 2 platted lots, as well as an illegal marketing sale of 2 duplex buildings as 4 townhouse lots in violation of the city's subdivision regulations and comprehensive plan. Poinsettia Place, which was platted by the city in 2022, depicted on the screen are the 2 subject lots. Lot 1 would be to your left. Lot 2 would be the lot to your right, with the blue line being the common boundary between the 2 platted lots.
Okay.
Excuse me.
What, and if you go back, what's the date of that plat?
2022.
Thank you.
Unfortunately, I can't blow it up, but I think it's, I'll get into that in the PowerPoint presentation. I believe I have the right date.
All right.
So if you go to the property appraiser's website, which we did on several occasions, you will see that lot 1 and 2, Poinsettia Place, have now been split into 4 tax parcels, which are noted in red. Now, they became tax parcels, which we'll get later on in our presentation, based on an application that was submitted by the respondent, Baber Enterprises, requesting that the tax parcels be issued.
Has the city made any, or sent any correspondence to the property appraiser saying this is an error, or should not have been granted?
We have not at this time.
Okay.
And here's an aerial picture of the 2 duplex buildings that are at issue. So on August 16th, 2022, that's the date that the City Council approved the plat for Poinsettia Place. The plat contained 3 legal lots only, and that included lots 1 and 2. There's a lot 3, which is not subject to this proceeding. It's currently undeveloped, owned by a third party. The plat is not platted for townhouses. There are no interior lines for townhouses, no HOA common elements, no requirements under 110-372 of the city's townhouse plat section of the code. So the August 16th, 2022 plat is the last and only lawful subdivision of the property. On February 13th, 2025, the city reviewed the internet, realized that the respondents were marketing the property for townhouses. We issued a warning letter on February 13th that was sent by myself. A copy is in the package and attached as an exhibit to the notice of violation. City advised the property is permitted only for 2 duplexes, which the respondents received building permits for. And the letter clearly states that the property is not approved or platted for townhouses. At that point, the owners are once again placed on notice that they have actual notice that the use limits and subdivision restrictions that are applied in this case. Moving on April 4th, 2025, that's the date that the signed application filed by the owners with the Brevard County Property Appraiser's Office. They request that the appraiser create 4 parcel IDs. The application, interestingly, explicitly states it's for tax purposes only. It does not imply suitability for parcel development. It directs the owner to contact local land development or planning and zoning for development questions. This application is yet another situation where the respondents are put on notice that the tax split does not create legal lots from the city's perspective. The owners do not contact the city as instructed. So at this point, if I may approach,
Yes.
I'd like to submit for the record the 2 applications that the respondents submitted to the property appraiser's property appraiser. And for your convenience, Your Honor, I've tabbed 2 pages. And on the tab page, you'll note that it was signed by Janet Baber Parsamo, which is one of the managers of one of the respondent entities.
All right.
Here are the 2 applications.
Thank you. We will mark these collectively as cities. Let's make them separate. So we'll do, no, let's just do this collectively, make it simple. Cities Exhibit 4. Okay.
May I proceed?
Yes, you may.
So from at least February of 2025 through November of 2025, excuse me. Apologize again.
Take your time.
The owners market the property as townhouse lots. And that's despite the February warning letter that the city attorney provided them, as well as the April notice in the application from the property appraiser. On top of that, in addition to the building permit that was issued for 2 duplexes, they nonetheless market the property as 4 tax parcels as townhouses, individually saleable units with separate pricing for each of the units, which can be seen in the exhibit attached to the NOV. I apologize again. Once this happened at an oral argument too, in front of the 5th DCA.
Take your time.
Over a cold.
It's all fine.
They market the property as 4 separate lots and saleable individually. They list the property on Zillow, as well as Remax Aerospace Realty, marketing these, purported townhouse units to innocent third parties. We also, when we sent the notice to the respondents back in February, we also noticed the realtor regarding this as well.
You're talking about your February letter that was also sent to the realtor? Mm-hmm. Okay.
Yes, sir. So the marketing represents, units as separately platted townhouse lots, contrary to the city approvals in the 2022 plat.
Did the realtor take down the listing after receiving your letter?
No, sir.
Okay.
In fact, in November, prior to the NOV, the property was still being listed by the same realtor.
Okay.
For the for townhouses. So
Beyond the scope of this proceeding, but I wonder if there's some licensing issues that if someone were to pursue. I mean, if an innocent third party were to purchase one of these, then they're being misled by the realtor. well, anyway, again, beyond the scope here.
One would think, Your Honor, and
Okay.
hence the serious nature of this notice of violation. So it's on September 22nd, 2025, the respondents finally get the certificates of occupancy issued for the two lots and the two addresses. Each of the COs designates the buildings on each of the lot as a duplex. So this is yet another notice to the owners about the official use classification from the building official confirming duplex use, not townhouse use, duplexes. Two-family buildings. Despite this, they continue to market as 4 townhouse lots even after the certificate of occupancy is issued by the building official. The actions of the respondents are just a continuation of an unauthorized subdivision of land. After receiving the plat approval for 2 lots and duplex COs for each platted lot, they continue to market for sale each unit as a separate townhouse lot. They represent 4 lots to the public when there are only 2 platted lots. And then they rely on a county parcel tax ID, which is only for tax purposes, as a means to market the property as townhouse lots. The city's position is it constitutes a division of land without city approval under 98-31A. In addition, it constitutes a violation of offering to sell unapproved lots in violation of 98-31B. Not even, and also to emphasize, it's just a misrepresentation to the public regarding what they have to offer for sale. So the specific violations of the code and comp plan, city's comprehensive plan requires the city to enforce subdivision regulations and zoning regulations. Chapter 98, which I just touched upon, to 98-31, subparagraphs A and B are applicable in this case. In addition, Chapter 110 zoning, which is also cited in the notice of violation, requires townhouses to be on individually platted lots and in compliance with 110-372 at SEC. The 4 tax parcels do not comply with minimum lot width and area requirements for R2 zoning and duplexes based on the tax parcel configurations on top of, everything. So the owner's conduct violates each of these provisions. And as we stated in the notice of violation, we believe
I wonder if you just go back. I'm taking some notes
Yeah,
from this here. So 110-372, townhouses require individually platted lots. And then okay, that was a citation I needed. Thank you.
And there are other requirements for townhouse lots. That's one of the most relevant provisions. They have to be on platted lots, as well as other design and criteria, and be in the proper zoning designation, et cetera.
Are you or could someone develop townhomes with R2 zoning?
The R2 zoning permits single-family and two-family.
Okay. So you couldn't not even have, well, I guess a townhouse would be single-family if it, or does the code look at it differently here?
That's kind of speculative.
Or single-family meaning an individual house, not a detached or attached house.
I'm not sure that, that's a question I don't know and not prepared to answer.
And I don't know if anyone there from the
but I would also
planning
add,
department
Your Honor,
can answer
that's
that.
not really what's at issue in this particular case. And at this point, Humpty Dumpty really needs to be put back together again, if I can use a children's fable. That's just not what was permitted in this particular case. Every step of the process were based on the platted lots based on duplex two-family building. That's Humpty Dumpty in its complete, unfractured
Yeah.
state, so. So the violations, which I think I touched.
Yeah, I think we hit
upon.
this.
Yep.
Yeah.
I might have gone in the wrong direction. As we noted in the notice of violation, this is a situation that required an immediate notice of hearing. Our opinion is it's a serious and immediate threat, especially to potential innocent third parties. The owners have received multiple layers of notice about the existing lots, the 2022 plat, the February 2025 city warning letter, the April 2025 parcel split disclaimer, and the property appraiser's application process. And also, again, in September, when the COs were issued for duplexes. The owner's violations meet the criteria for serious and immediate threat to the public health, safety, and welfare pursuant to 162.06 subparagraph 4, because their actions compromise the city's ability to regulate land use and permitting, the creation of illegal, unpermittable, unfinanceable parcels, tax parcels, a disruption of the city's subdivision controls approved by the council, and a potential for consumer deception and fraudulent real estate transactions. Unless there's any questions at this point, I will sit down and reserve some time for a rebuttal.
And I'm probably splitting hairs here, but I would agree. I see how this would be a serious threat to general welfare. Health and safety, is that just kind of lumped in together, or is there anything specific dealing with health and safety?
It's just lumped in together.
Okay, that's what I figured. Okay.
Yeah, it's more of a very serious situation involving consumer protections.
Right.
And,
Yeah, and let me ask this. Typically, if I were to issue an order imposing fines, I think the statute would require some kind of delay before it is recorded in the public records. It would seem to me that there would be nothing that would preclude the city from recording any order that I would issue here today onto these lots, right? Are you aware of anything that would prevent the city from doing that?
I'm not aware of anything that would preclude us from.
Okay, I'm just thinking in terms of protecting innocent third parties.
Yeah, the statute, I'm going to address it in closing.
Okay. All
But
right.
as you know, the statute, we've notified the respondents at this point.
Okay. And are the
If there's a
respondents
pending-
here?
Yeah, I believe so.
Okay.
If there's a pending code enforcement action,
Yeah.
property owners are required by law to notify any potential transferee, and that's under Chapter 162.
Right.
At the very least, if there was any transfer, they would have to provide the notice of these proceedings.
Right.
And the statute says if they do that and they don't provide the notice, it's a presumption of fraud.
Right.
So with that, the statute doesn't specifically address recording the initial order.
Okay.
But nothing in the law prohibits us from doing that.
Okay. All right. Okay. I would like to hear from the representatives for the property. Is that either of you? Please, if you would come to the microphone. Yes, you must go up there so that way your what you state is recorded for the official record. If you please introduce yourself.
Does she need to be sworn in?
Did you raise your hand if you're going to be offering any
Well, they
testimony?
weren't looking at me, so I guess I would need to be sworn in.
All right. Please raise your right hand. You swear the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Thank you much.
Okay, I'm Jan Baber Parasmo, so Baber LLC is me.
And I'm sorry, and Jan Baber and your last name?
Parasmo.
How do you spell that?
It's Parasmo.
Parasmo. All right, Ms. Parasmo.
Okay, I've been in business myself, retail business, for umpteen years.
Just before we move on, could we have an official address for the record?
685 Hermitage Circle in Palm Beach Gardens.
Okay. Okay, thank you.
Okay, is that good?
Yes, thank you.
Okay, I'm being accused of doing all kinds of fraudulent things, which is just beyond shocking to me.
Okay.
I've never done anything fraudulent in my life, nor do I know anything about building, unfortunately. My ex-husband, Gary Whittekin Enterprises, did all the building. I just backed the building of it. He got the permits, he did everything, and unfortunately came down with terminal cancer. And
Okay.
I got a notice in February about not advertising as duplexes. And Gary could hardly talk, but I tried to get something out of him because he lives up here. I live down there in Palm Beach Gardens. He said, hey, look, it's going to be okay. You just need to get the parcels separated for taxes or whatever. He could barely talk. He said, get a hold of Michelle, and I'm trying to find out Michelle who. He couldn't find the number.
Okay.
Anyway, later I got Michelle's number and said to her, Gary, I guess y'all talked about this, need to separate the properties.
And before you move on, who is Michelle? Do you have a last name?
From Landmark Title.
Okay.
Not that she didn't do anything illegal either. She gave me a form to sign to get the separation. I knew nothing about it, but Gary said this will make it fine and convert them into townhouses, not knowing anything or what I'm signing or whatever. I'm
Okay.
sorry to be so stupid, but I was not
Okay. So this
in
is
business.
this apparently is the application that went to the property appraiser?
It was an application, so I'm assuming she was presenting it and had me sign it.
Okay.
So I'm assuming that's what you're talking about. So we did that. I was told in May that that got done. It was official in May that they were split and separated. Didn't receive any other kind of notice, but we did address the February notice. And Gary said, this is what you have to do to correct it. And after that, I don't know how. Again, I know nothing about it, sorry. That makes them townhouses.
Okay. Did you reach out to anyone at the city's planning and zoning department, building department, any city department to?
No, at that time, I'm so sorry for any and all of this. I didn't know who to talk to. Gary did all the talking. He was not in any shape to call at the time, but in February, we did cease advertising them. He said we did not. We ceased advertising them as townhouses and went to duplexes, but then when I was told about this subdivision, then you could, just stupidity.
So then the advertising
Then we switched
reverted to
back
townhomes.
Townhomes.
Okay.
So they were continued to,
Okay.
nothing was malicious, they continued to be advertising as townhomes until we received this notice of a code violation. So we stopped immediately, even though the attorney is saying they were still continued to be advertising. I don't know where you got that information from, but no, we stopped as soon as we got your notice. I mean, it was.
Could you talk into the
Pretty
microphone?
serious
Because I
notice.
just
Oh, I'm
want
so
the record to reflect what you're saying,
okay.
because if you're not talking to the microphone, then.
I'm so
no one-
sorry.
no one-
I
Thank you.
never do this.
That's okay, that's okay.
Okay, so I'm trying to contain myself.
Take your time.
Anyway, unfortunately, Michelle from the title company was doing this, and then unfortunately, my ex-husband died.
Okay.
And, excuse me, in April. So I was to handle all of this, which was, I run a business, so it was just overwhelming. And next thing I know is I I got the letter from the attorney, and that was in November. Again, nothing was done malicious. Unfortunately, I didn't know about all these laws. I've never heard so many laws in my life,
Okay.
And codes, and
Okay. I think I understand what happened here. Do you want to add anything before we turn it back to the city?
again, I mean, I'm just terribly sorry. I came here today to see what I can start doing to get things back in order.
Okay.
And I do have a question. To have the parcels split into 4, which the landmark title, they weren't doing anything wrong to my knowledge, but I believe the attorney is saying that was illegal. If it's illegal, why did they let them do it? I mean, I don't understand any of that, but they were able to split them for the taxes. If it was illegal, why did it get done? Or
Well, that would be a question for the property appraiser. They didn't check, apparently. They didn't check to verify that there was a separate parcel for each, for each of them, would be my supposition. Okay.
I don't know, but the
Okay.
survey at the time that possibly was presented, again, I don't know, said on the survey, or they had to change it to say duplexes, or she submitted it as duplexes to change still for the parcels on the taxes, tax IDs, and then we received the tax ID numbers, and I
Who is
just thought-
chief? You referred to chief? You said our chief?
No, Michelle from Landmark
Michelle,
Title
okay.
got this done. Again, nothing illegal on her part. This is what I asked her to do because of Gary saying that's what we need to do. Didn't know he wasn't going to be around to finish this through. So if you could tell me what to do,
Okay.
I'm more than happy.
Okay. Well, I will be issuing an order requiring remedial action based on what the city has told me and what you've represented. Anything before I let the city have the microphone back?
Who are you addressing?
I'm addressing you. Would you like to add anything before Mr. Garganese returns to the microphone?
He said there was a bunch of notices out there. I don't know what he's talking about. I know we had the February and then this November
Okay.
notice, so I'm clueless on all these notices.
Well, those are
And-
2 notices.
Oh, well, he was saying multiple notices. I wrote that down from his statement. And the reason Gary didn't sign, obviously, is because he's not here
I
anymore.
understand.
So that was forwarded to his sister's address
Okay.
in Colorado
Okay.
to clear that.
Okay.
So I don't know what else to say, except
Okay.
I'm here to see hopefully y'all can guide me and tell me what to do, because
Okay.
sounds like I have a mess on my hands.
Okay.
But
Thank you very
didn't do
much.
anything intentionally. Okay,
I
thank you.
understand your testimony. Thank you. Mr. Garganese, any rebuttal?
First, my condolences to you regarding your ex-husband's passing. The only thing that we have to add, Your Honor, is just the remedy that we're seeking, which I believe will answer her question, hopefully. So based on the testimony, based on the evidence and testimony presented at the hearing, we respectfully request that the special magistrate find the respondent in violation. City requests that the magistrate order the respondents to immediately cease all marketing or representation of the property as townhouses or individually platted lots, and direct respondents to comply with 162.06 subparagraph 5, the seller disclosure requirements for any transfer under the Florida statute, with obviously the note and caveat that we would hope that during the pendency of this proceeding, there wouldn't be any transfer without providing proper notice of these proceedings to any third-party potential buyer. Second, we ask that the order require respondents to rescind or consolidate the 4 county parcel IDs and restore the lawful 2-lot platted configuration per the Poinsettia Place plat.
Okay.
And then essentially put Humpty Dumpty back together again.
Okay.
And then provide written proof of compliance to our code enforcement. We ask that the special magistrate require respondents to do this restoration by January 2nd, 2026, to provide the city written proof of compliance. And if they fail to provide this proof of compliance, city recommends a fine of $250 per day for each of the 4 violations be imposed until compliance is verified. And of course, the city requests that all costs associated with enforcement of this violation be assessed against the respondent. That's our formal request.
Okay.
You know, with respect to the respondents' concerns, they submitted an application to get the 4 tax parcel IDs. I would suggest that they contact the Brevard County Property Appraiser's Office and ask that the original tax parcel IDs be restored. That coincides with the 2 platted lots in the Poinsettia Place plat. And to remind the respondents that, notwithstanding, you know, Mr. Whittakin may have been the primary person responsible for the permitting, and their contractor, ABC Concrete, also being responsible for construction, that they did apply for permits for 2 duplexes, 1 duplex on each of the platted lots. The units are not, city's position, available for individual sale. They're duplex buildings from the city's perspective, and I would hope that the respondents respect the decisions that were made by the city council in permitting for the city.
Right. And so basically, a townhouse will have individual ownership, whereas a duplex will have one ownership over 2 different units. Is that correct?
Correct.
Okay. All right. Thank you very much. I think
Thank you, Your Honor.
I think I'm ready to issue my findings and conclusions of law and order on this. I'm going to find that the respondents do own the subject properties, I'll call them, at 115 to 117 Jefferson, and then the other at 119 to 121 Jefferson. I find that the zoning here is R2 medium density, and that the Poinsettia Place plat established 2 different lots, and that, of course, is in the record. We have a picture of the 2 lots. That there were building permits issued to build 2 duplexes, that a duplex was constructed on each of the 2 lots in accordance with the development standards for the zoning district, which allows for 2 family dwellings, a duplex, under common ownership, that neither of the lots were reviewed by the city's planning or building departments or divisions as a townhouse project. That's very clear to me. I understand from the record that in early February, the city learned that these 2 lots were being marketed as 4 lots through Zillow and then Remax Aerospace Realty, and that the city attorney sent a letter on February 13, 2025, advising that the properties were could only be permitted for 2 residential duplexes, that they had that there was a advisement in the city attorney's letter that the division of land within the city of Cape Canaveral must be approved by the city council in accordance with the requirements of Chapter 98 City Code. So the approval could not be given by the property appraiser, must be given by the city council. At least at that time, that's how platting was done. On September 22nd, 2025, the city issued a certificate of occupancy on each of the two parcels here for a duplex on each one. And that there was a request, and I believe it was April, I'll get the date down, where there was a request to the Brevard County property appraiser to create 4 individual tax parcel identification numbers corresponding to each dwelling unit instead of 2 units or two different parcels as the platting required. I find that there has been created an unlawful division of land in violation of the plat, in violation of the city's subdivision regulations, and also the comprehensive plan of the city, which requires that the city enforce the subdivision regulations. I find that the marketing of the subject property, it's unclear to me whether it's continuing as of now. The testimony was that the marketing ceased upon receipt of the notice of violation, but at least at some point there was illegal marketing of the subject properties for 4 lots, for 4 individual townhouses. I do find that this is a serious threat to the general welfare. I am concerned about innocent third parties who may purchase one of these units, one of 4 units, and thinking that they have fee ownership of one of 4 units, when in fact that's just not how it works when you only have two parcels that could be sold. So I'm concerned about that, and I'm going to include in my order a requirement that the city record my order in the public records for each of these parcels to hopefully provide some protection to an innocent third party. I do find that notice was properly given. We have a whole exhibit on that, City's Exhibit 3. The definitions of what a townhouse is and a 2-family dwelling unit, those are all in the zoning code and make clear what is supposed to happen, which were 2 dwelling units, duplexes. There's a violation of comprehensive plan policy land use 1.3.1, which I find there's an inconsistency with it, not by the city, but by what has happened here. I think the city is properly enforcing its subdivision regulations. I do find a violation of section 98.31 of the city code, which does require the city council to approve of the subdivision of land, the platting of land. I think there may be some administrative ways of doing that nowadays after recent legislation, but at least at the time all this was happening, that had to go in front of the city council. That same statute, or the same ordinance, 98.31, says no owner of real property shall sell, offer to sell, or lease lots or tracts of land from such property without first having divided such property in accordance with the requirements of this article. And then there's a whole host of other requirements, including surveys. No permit shall be issued for the construction of any building or structure, or for electrical or sewer hookup on any lot or tract sold in violation of this article. So a third party, couldn't even get electricity into these units if they're sold in violation of the city codes. Again, it's a serious matter. There is a violation of section 110-372. It says each townhouse unit shall be located on an individually platted lot. That's very clear. That's not what was happening here. As far as the advertising, there's no First Amendment protection for unlawful advertising. I'll put that out there. So I'm going to, even though the respondents have said they're no longer advertising, I'm going to include in my order to immediately cease and desist from all marketing, advertising, or representing the subject properties as as individual townhouses or as 4 subdivided lots. And then I'm going to require that the respondents coordinate with the Brevard County property appraiser to rescind or rescind the prior division into 4 tax ID numbers and to have them reconsolidated into 2 tax identification numbers as it previously was done. And I will accept the city's requests that occur by January 2nd, 2026. So I would urge the respondent to get with the Brevard County property appraiser this afternoon or tomorrow. They're open for a couple more hours today, and start the process of restoring it back to where it has to be under the law, and to furnish documentation of compliance by January 2nd, 2026. I'm going to order again, I think I mentioned this before, I'm going to order the recording of this order by the city as to each of these parcels to hopefully protect any innocent third parties. I will offer this as a word of caution that the deadline is very serious. It is, if there's a failure to timely comply, then the code officer will request another hearing before me, and at that point, I would be inclined to fine the respondents $250 per day per violation. I think there were 4 violations here, so that's $1,000 per day. You don't want to be in that situation, so please get this taken care of immediately. Just go over there today, tomorrow, get this taken care of. As I mentioned at the beginning of the hearing, any fines that I may issue for noncompliance would become a lien in favor of the city on all real and personal property of the respondents. And also, if it's, I think in this case, it would be non-homestead real property is subject to foreclosure. So I would say by all means, get this taken care of so we don't have to go down that road to the parade of horribles. And I do appreciate how this happened, and the unfortunate circumstances of your former husband's passing. I don't think that there was any maliciousness on the part of the respondent, and I appreciate the respondent's willingness to get this remedied. And again, I would urge her to do so promptly. Is there any further business for today? All right. In that case, we'll adjourn. Thank you very much.